Okay. Hello, everyone. Thank you for attending our Ask the Lawyer panel. My name is Jim Cook. Just to let you know, we've got panels galore throughout the day, lots of great films, and also don't forget our Filmmakers Breakfast, which is tomorrow, and more panels after that. So be sure to check out your program journal. And I would like our lawyers here to introduce themselves and tell us your area of expertise.
Hi, my name is Michael Prywes. Technically, we are call ourselves experts, but I'm a former film producer, and actually was here as a film producer many years ago. We did pretty well with that film. It was a film shot in 35, and it had a couple of name actors. We were theatrically distributed. We were distributed on DVD. We also had foreign sales agents. During that time, I learned a lot about law informally because I learned about partners and when to have them and when not to. I also learned about crooked sales agents because the Southeast Asian rights to my film were sold without my permission. I also, my second feature fell apart, and I ended up bringing a pro se lawsuit against the other producers, which inspired me to go to law school at night while I worked in production and then distribution during the day. And so I've learned a lot through experience. I am now an attorney that's devoted only to transactional work, not to litigation, and our law firm serves artists and entrepreneurs. The name of the law firm is Prywes Schwartz.
Hi, I'm Marc Jacobson. I was on the board of this august organization for many years, and when I left Long Island, I resigned, and they made me counsel to this group. I've been practicing law for almost 40 years. I am the founding chairman of the New York State Bar Section on Entertainment, Arts, and Sports Law, which has 1,700 members. I'm licensed in New York, California, and Florida. I taught entertainment law at 3 law schools and the New School. I testified before Congress and wrote the principal legislation regarding the Digital Millennium Copyright Act. I went to the World Intellectual Property Organization and testified there. At the time, I was the general counsel at Prodigy, the online service, and we were most interested in the notice and takedown provision, which has become really a very interesting part of the law today. Right now, my practice is principally focused on music and film. I also don't litigate. We just do transactional work. I have films in my office ranging in budget from $10,000 for a short to $120 million for a very expensive sci-fi picture about the loss of gravity called Inversion. So I'm doing all the production work for that. On behalf of Michael, I want to suggest that when we answer your questions, we are answering them not as your lawyer, and that you cannot rely on that advice. You cannot bring an action against us. No attorney-client relationship has been formed here, and that's for those of you watching this as well. It's very important for us to make that clear, but we'll answer your questions as best we can.
Okay, so let's just dive in right away. Does anybody have any questions for our lawyers?
Any topic.
Any topic. Okay, right here.
With so many more films being made now, a lot of people, I'm sure, are making films to better consult a lawyer. What's something you wish that they would know before they start production?
So I'll try to be the English-to-English translator. So what would you like? Actually, say that one more time.
They want to know what filmmakers should know before they talk to a lawyer.
Thank you. You have better ears than I do. Thank you.
Well, the short answer is they should read a lot. They should read a lot of material that's online in my mind. They should read all the books that are out there, from Reel to Deal, there's lots and lots of books that you can read about making film. It's good to have that knowledge. And I don't know, the real challenge that I find is we're always asked to quote a flat fee for a production because there's a line item in the budget, but it's very ambiguous as to what that covers. So that's part of the discussion you need to have.
The first thing I would like a client to consider before coming to an attorney is being realistic about what filmmaking involves. If you're painting a canvas, well, you need paint and you need canvas, and maybe that's it. The reality is film and a lot of film-related ventures are in fact collaborative and require money. And the fact is that part of your tools and your toolkit must be bookkeeping, accounting, law, permits, locations. All of these things involve money. And so my big concern is when people come and they want to shortchange, let's say, a crew member or a cast member or an attorney. I would love for filmmakers to really be realistic about what the costs involved are for putting together a given project.
Anyone else? Right over here.
I have a question about like clearances. Basically, what if you have things in your scenes that are either scripted or not scripted? Like if you have either a principal actor wearing a rock band T-shirt or something like that, or if it's just someone in the background who you can't see their face, but there's you can see some advertisements in a public place or the name of a restaurant. Are those the kinds of things you need clearances for?
So, question of clearances.
The first thing I would say, again, I will reiterate what Mark said, and that's we are not able to provide legal guidance, and this is very much a case-by-case basis kind of question. However, what I will say is this, let's talk practicalities. If you can make the project good without having an unclear trademark, logo, what have you, in the background or even in the foreground, if you can do it, my opinion is you do it because whether or not you can claim fair use, and fair use is frequently misunderstood. The reality is you don't want to get sued. And our jobs as attorneys is to reduce risk as much as humanly possible. So as far as I'm concerned, unless it's necessary, do what you can to avoid having trademarks, logos, mentions of names. There's also there are clearance houses like there's the Forest Act 1, but do it right, because your success, if God willing you have great success, you don't want somebody coming after you because you didn't go about clearing that item that you didn't even think about. I don't know if you guys are familiar with the Budweiser lawsuits with Flight, I think it was. Is that the Denzel Washington movie?
Oh, yeah.
Yeah, I just did.
Right, and I think Anheuser-Busch lost. But you don't want Anheuser-Busch coming after you. You know what I mean? So the reality is there's practicalities, and then there's the law, and it is a case-by-case situation.
I agree with everything he said. Put yourself in the other side's shoes. We go to law school to learn how to do that. That's what really being a lawyer is all about, understanding the other side's position. So if you have to ask the question, you probably shouldn't do it. And if you run that, and you're doing a low-budget film that way, you'll do really, really well. So what we do is we look at the other side. Now, if it paints the other, if the product is painted in a bad light in that particular scene, then you're more likely to have a claim against you. If it's painted in a positive light, you could still have the claim against you, but it won't be as bad. I have a client, I represent a photographer named Ruth Orkin. She passed many years ago. There's a very famous picture of hers called An American Girl in Italy. It's a woman walking down the street, and there are 12 men just ogling her. I know you've all seen it. And it was above a bed in a scene where a woman was being raped. And it was intentional, because that picture is about, in a way, it's about sexual harassment. So we brought a claim, and we settled it very quickly, but we didn't want that to happen. So it's a real problem, and the rule is, if you have to ask the question for clearance and you're on a low budget, don't do it, because you'll save money.
Right over here in that.
Could you talk a little bit more about fair use?
Let's talk more about fair use.
talking to a friend of mine on the way out here, and I said, I know there's going to be a question about fair use. Fair use is impossible to give you an answer for, as Michael said earlier. There are 4 statutory factors that go into place, which is about the nature and the character of the use, how much of the work you've actually taken, whether it affects the market for the work that you've taken, and one other which I don't remember off the top of my head. But the new case law talks about whether or not the use of that work is transformative or not. And it is very much in the judge's or jury's eyes what constitutes transformative uses. And if it is transformative, it will be fair use. It's really hard to give you an answer, even if you gave me the exact facts as to whether it's fair use, because we would have to go, in my opinion, have to go do legal research on the subject. And that's really a challenge. I don't know how else to say it. If you're going to rely on fair use and you're in a narrative film, it's a very big deal. If you're relying on fair use in a documentary, it's a big deal. It may or may not matter, because the documentary has First Amendment protections, which a narrative film doesn't necessarily have. So those are the broad strokes on fair use.
Yeah, fair use drives me crazy, because I actually think that the fair use is getting broader, but again, the practicalities are, do you want to get sued? Big in the news lately has been Richard Prince, who made canvases from other people's Instagram photos after winning a case just a couple of years ago called Prince v. Carrier, where he appropriated another photographer's photography but transformed them, and they found it transformative. Now he's pushing the envelope with these Instagram photos, because he used them exactly as they were, except he blew them up and he provided commentary. And he's daring somebody to sue him. But then again, he's a very wealthy artist who has the ability to defend the work. He's selling each one of these canvases for between $90,000 and $2 million. So the fact is you've got these fair use cases that ultimately are going to litigation. There's another one that really made my skin crawl, where a photographer was taking pictures of people in their apartments. I don't know if you guys had heard about this, the neighbor's case. And he had a very long lens, and he took pictures, including an unclothed child. And he included this in the exhibit. And I think it was the Northern District, but one of the courts found that was okay, not because they thought it was okay, and they gave dicta saying, listen, we think that the legislature should have laws against this, but we can't find anything in the law. Now, this was actually more like privacy claim, but one of my concerns is that when people are depending on fair use is a response to a choice you've already made, if that makes sense. It's an affirmative defense to infringement, so you really have to be very careful.
I just want to put another point on three things you said. First of all, fair use is, as Michael was saying, fair use basically says, yes, I infringed your work. I admit that I infringed, but I'm allowed to. That puts the burden on you to prove that you were allowed to. It's a huge obligation. So the claim is made, and then you raise the defense. So you're in court no matter what you do. So fair use is a big deal, and you have to be very careful about it. To the two cases, the Prince cases, the Instagram photos are not protected by copyright, because of the terms and conditions of an Instagram account, when you publish your photo, you give away your copyright. So the owner of the photo no longer has a claim for copyright infringement. So he can do what he wants with those pictures. The challenge under the Prince v. Carrier case, however, is that if you looked at the images, there were maybe 30 images in the case. And the judge said, this one is transformative and this one is transformative, but this one is not. And for me, I can't tell the difference between the images. So it becomes wildly subjective. And if you're going to rely on fair use, you need to really think hard about it for all of those reasons. And I wouldn't. Unless maybe it's a documentary.
Anyone? This gentleman right here.
So, as everyone knows, it's very expensive to fund films. So, how do you guys feel about using finders for film finance?
How do you guys feel about
Using
The question is, how do we feel about using finders?
finders? Yeah.
Finders are illegal. Let's start with that. Okay? Unless you are a registered broker-dealer, you cannot take a fee based on the closing of the transaction. So if you were to come to me and I were to say, oh, I got this guy that'll give you $250,000 for your movie and I want 5% of it, you're breaking the law, I'm breaking the law, and that guy can come back and take the $250 back from me and you if the film goes south. So how do I feel about it? I feel like you have to do it. Okay? That's not legal advice, it's very practical advice. And you see people put on up but they're illegal. I mean, I just went through this yesterday with someone who was helping someone find money for a play. And the guy said, I want 10%. And she said, I can't give you 10%, this is nuts. I don't have it to give, I'm a finder, you're giving me money, you're introducing me to somebody else. So, finders are all over the place. And what the Jobs Act did, and the new legislation that allows for offerings to be made on the internet, is an attempt to eliminate that problem, just like Kickstarter does in exchange for gifts, you can raise money. There is now an ability to raise money on the internet in a solicited offering, which is a big deal, funds, but only from accredited investors or from non-accredited investors who invest up to 10% of the net worth. So it's part of the reason. It's a fact of life in the movie business, and most people couch those deals in the form of an executive producer agreement, and not as a finder. So they're illegal, but they're widespread.
Yeah, I would repeat everything he said. Another thing that I'd like to answer your question about before coming to a lawyer is recognize that you can't just go out and ask for money. People do it all the time, but more likely than not, you're breaking the law. If you are offering in exchange for equity, which is what Marc is talking about, Kickstarter, Indiegogo, Seed and Spark, these are all donation-based. The minute you're dealing with equity crowdfunding, or you're doing a private placement memorandum and offering, you're dealing with securities. This is a bigger deal, and so you have got to make sure that all your I's are dotted and your T's are crossed, and that you're doing everything on the up and up.
You had a question over here.
Can you talk about the difference between work for hire versus independent contracting?
Work for hire versus independent contracting.
All right. And we actually had a long conversation about this yesterday. Most of the time, you should not be designating or classifying somebody as an independent contractor. Back when we made our film, I know we 1099'd a whole bunch of people. Most of the time, you can't do that. The reality is that most of the time, the people you have working for you, certainly if you're controlling anything more than the results, are more likely employees than independent contractors and have got to be treated as such. So that's the first thing. Even when you're talking about people with loan-out companies, such as, a cinematographer with his own equipment or a sound person with his own equipment, big actors, they may have their own loan-out companies. Then you're dealing with a company, and that person is an employee of that company, so they're not your independent contractor. Truly, the only way you can have an independent contractor is if you're not in control of their day-to-day, and you're only in control of determining whether you'll accept those results. That's the basic. There are a lot of rules related to independent contractors, and they're widely unfollowed, and these days departments of labor are cracking down. Work for hire is defaulted to the employer-employee relationship. So if you're dealing with an independent contractor, and the independent contractor is creating some sort of intellectual property for you, the reality is, unless you have specific provisions in a contract, the default goes to the independent contractor being the owner of that intellectual property, the creator and owner of that intellectual property. There's got to be an assignment of rights.
It's not going to be an assignment of rights.
Well, I mean, in a contract.
It's a work for hire.
Well, you have a work for hire, but you also say, in addition, you want to be able to assign any rights that is involved in the creation of this work. Because the fact is, work for hire, by its doctrine, is related to the employer-employee relationship. That's my understanding of the default.
So every contract that you sign in your film has to have the magic words in it, that this is a work for hire. I mean it, magic words, has to say that. That's what the statute says. If you're going to use someone as an independent contractor and run the risk of a state audit or a federal audit for failure to pay on insurance, that's up to you. But the contract still has to say it's work for hire. Because the concept, as Michael was saying in the beginning, was the default under the current statute is that if I am the cameraman and I don't sign a contract, I own the copyright in what I create, okay? But if I sign a contract that says it's work for hire, the employer owns it at that moment of creation. That's the difference between assignment and work for hire. Every contract for every person who works on the film has to have the magic words in it.
Could I also just add to what you're
Sure.
saying? You know, I'm not a lawyer. You said something that's really important, signed.
Right? Oh, yeah.
A lot of people, it's just going back to something even simpler, a lot of people just rely on verbal or just emails or whatever, and it's just, that's not enough. If you have to have it on paper, signed,
By both sides.
by both sides. Just had to throw in that 2 cents. So,
One more thing, if it's not signed, keep in mind that emails between you and whoever you're dealing with can be construed as contractual agreements if there are demonstrations of affirmation to agreement to do something. So saying, but we didn't agree on that. We just had emails back and forth. Well, guess what? If you didn't have a signed contract that obliterated all prior things and made it within the four corners of the contract, well, then technically you can possibly go to those emails and come up with some sort of contractual agreement.
But a signed contract would trump any of those emails.
If it has the proper provision that
All
says...
merger language. That all the prior discussions are merged into the contract.
Okay.
Yes.
There was a case, if you want to talk about a case, I can talk about a case. There was a case in the Southern District last year called 16 Casa Dux, I think it is, D-E-U-X, I don't know. But the director of a film didn't sign his contract. And he took the position that he owned the copyright in the film. And he didn't like the way the producer edited it. So he went to court and sued for copyright infringement and lost. Simply because the overall approach of the director was with the producer's instructions, and the fact that he didn't sign the contract, he was just being a jerk, is really what the court said. And if you looked at if you read the decision and you saw all the paperwork going back and forth, the guy was a jerk. So the court found in favor of the producer. But you can't rely on that because you got to go to court to get that result. So that was one. The other case that came out around the same time, which was recently reversed, which is very interesting, was this case called Garcia, where an actor in a film was duped into appearing into a film that basically was the cause of the riots in Benghazi. And she took the position that she owned the copyright in her 5-second appearance in this movie. And the court in California held that in fact she did.
Wow.
Which completely would throw everything that we do for a living out the window. There was an en-banc hearing, which meant that the 3 judges who decided that in the first place allowed their 6 other partners on the bench to hear that, and the en-banc hearing said, no, you guys got it wrong. This girl doesn't own any copyright in that. She may have been duped, and there's a really good contract claim, but there's no copyright claim. So again, so that went through a trial at the state court level, an appeal, and another appeal before it got the right result. So the point that we're making, or that Jim is making, is get the papers signed.
I actually have a question for you, Mark, because in the Garcia case, it was Garcia against Google, and she was getting death threats, and she, I believe, this is the question I have, was it a DMCA notice, a takedown notice, and Was that, because...
I don't remember.
The reason I'm asking this is because you've got one of the foremost experts here in DMCA, Digital Millennium Copyright Act. When I worked for a distribution company, we responded quite a bit to, we sent out notices to to Google regarding the unlawful distribution of our films. And the real question here was, can this actor control the future of this film, and but also control the use of her image, her likeness in this film, because she was getting death threats. And this was an issue of sympathy for the court from my perspective, that where they didn't want to see her getting threatened. That there's a concept in Europe that's not applicable here called moral rights. But one of the arguments is, what happens if you grant her copyright in her performance? Does that mean, and they used in the opinion, they're like the fifth orc in Fellowship of the Rings, does he not like the way he was portrayed? But it really does become a slippery slope, and it gets back to the question of collaboration. When you have all these different people collaborating, who is the owner? And you really need to get that hammered out before you even get started.
Mark, did you want to finish something? Or?
Yeah, I wrote an article on the subject, so if you want it, let me know.
Okay. Corey?
At what point during the filmmaking process is the filmmaker obligated or wise to present a contract to any contractor or employee?
At what point is the filmmaker obligated to present a contract to employees?
Because I'm usually presenting the contracts while I'm loading my stuff out of the location.
That's the wrong time.
Do I have any right or any reason to request a contract ahead of time? Like
Yes.
in a pre-pro phase?
I'm a believer that contracts should come in the very beginning. You and maybe have a conversation where you absolutely do not commit to anything. You talk about things, and then I personally believe that should go into the contract stage. So and in negotiating a contract, because then you've got it in writing. You've had the conversation, but then you're done with it. You have. I don't understand, and I think this is true in life. I don't understand when people don't express their mutual expectations right off the bat, because that's the way problems are avoided. And I know people want to be nice, but there's nothing not nice about engaging in a contractual relationship.
Without signing, because I don't know what I'm signing.
And that's part of it too.
There's plenty of seats on this side if you want to come through, we don't mind. Let me finish with you, Corey. I think that you're an employee on the film. What your incentive to have a contract signed is to get paid. You don't know when you're going to get paid. You don't have a contract saying when you're going to get paid. So it's in your interest to know when you're going to get paid. That's the key, and that's why you should have a contract early on. From the producer's perspective, he wants to have a contract with you early on because he doesn't want to take any, I hope he or she doesn't want to take any of your ideas without paying you for them. That's the other side of the coin from the producer's perspective.
Well, my situation's a little bit trickier because some of the props, the custom props and the custom scenery or just scenery, it could be bed sheets, are mine, are my possession. So that work for hire for me, and I realize it's a private conversation, I have to hire a lawyer, but it's trickier for me because it's my stuff. It doesn't really belong to the production unless the production is willing to pay for it as a line item, correct?
Well, I don't know, a bed sheet doesn't really have any originality around it.
It does if all the action's happening in that bed.
Well, no, the bed sheet, the sheet doesn't have any originality around it, so it has no copyright protection. So if you're going to provide a location to somebody and provide them with other aspects, you might get a location agreement, but if there's a particular mask or
No, if
something.
I'm on a location, any location is a separate deal from my production design and or set design. And I might embellish the sheet. so that makes it custom and.
Right, and therefore you need an agreement technically before you do that for the producer to own your embellishment, which he should do, because he needs to own that as a work for hire, because you're doing it for the film. The other key to this is there's a case called about Captain America. It's an old case where they signed work for hire agreements after the fact, and it was found to be not binding. So to some, people don't raise it. Captain America was a very big deal. There was a lot of money involved, but in most of the independent films that we're talking about here, if you sign a contract during the course of production and shortly thereafter, no one makes a fuss. I've seen music license agreements get signed 5 years after the film gets released. So that happens. It shouldn't, one shouldn't do that, but it happens a lot.
The other element to this is that it inures to the benefit of the producer. The reality is that the producer may or may not have, an attorney may or may not have insurance, but the reality is that you as a producer, I as a producer, or you as a producer, want to be able to go to a distribution company and be able to say, I've got everything properly documented, I got all my contracts, I've got all my clearances, I've got everything on the up and up. Because it's the last thing that the distribution company or the production company want is a lawsuit. And this comes into play with employment and 1099 situation. We were talking yesterday about the black swan situation, where interns sued over not being classified as employees, and it wasn't quite reversed, it was sent back down because it was based on the wrong threshold. They determined that internships are based on who's the primary beneficiary. But the reality is that they were still sued, and they were sued because it was a successful film, and people involved wanted to get paid. And the reality is that a production company or distribution company does not want the production designer to come back and say, I made that, and I wasn't paid for it, and there was no contract, and give me my money. They don't want that. So it inures to a producer's benefit to do everything on the up and up and not try to cut corners here.
Actually, I have a gentleman right here.
The topic of what you can show in the film. Say there's a scene where you're showing streets or protagonists or anybody walking in the streets. What kind of or if the name of the shop is visible, is it loud or? Because when somebody is walking in the street, it may be very difficult to hide every particular shop or something.
So if you get the name of a shop or something in your shot, what do you do then? Is it allowed?
Again, this is a case-by-case basis, and this is definitely something that I think that an attorney should be consulted about. And it depends on the nature of the film. It depends on if what's going on is in any way reflective in a good or bad way towards that shop. Again, my personal opinion is do what you can to avoid using other people's things without their permission. If you get their permission, that's even better. There are, and again, this is from a practicality standpoint. When we just talked about fair use, you had somebody who was a photographer taking pictures of people in their apartments and got away with it. Well, there may be broad latitude, but do you really want to be sued and have to find out anyhow? If it's really that much easier to just ask the shop owner to be able to shoot, and get that signed, then it just may be easier and better for you down the road.
But say like you have a scene that the protagonist is walking on the street like just randomly for the next 1 minute. Are you going to ask each and every shop, like there may be 200 shops on this?
It depends.
On what?
It depends. That depends on the shot, what's going on in the scene. It depends. Can't give you an answer.
Actually, I have some back here. We have like 5 minutes left, so if we want to speed them out, I want to make sure.
Quick question. With films based on true stories, where the main character is actually painted in a really bad light and he's still very much alive, and the names are all changed, but the location isn't and the story isn't. can I say this is based on a true story, or should I do exactly the opposite and say this has nothing to do with anything in reality? This is just a fiction.
Well,
Can
you
I
never
say-
want to lie, let's put it that way.
Right, so I want to say, yes, this is based on a true story, but even with the names changed, can I get sued?
No, yes, the
Yeah.
answer.
Okay.
Anybody can sue anybody for anything, anytime, anywhere. So the question is, can you get sued? Is always yes. When you win is another story.
Right.
So, I would suggest to you that, and part of that anytime business relates to the fact that in the US, you don't have to pay attorney's fees to the loser most of the time. In copyright cases, you do. But in England, the loser pays attorney's fees, so they don't have as many lawsuits as we do. So you have to assume that there will always be a lawyer to bring the lawsuit that you think is ridiculous, okay? There's always a lawyer to do it, and I can attest to that from personal experience, having been involved in those. So, not as the guy who brought the lawsuit, the answer to your question is, if the guy is alive and he can be recognized by someone in law school that I was taught was named TARM, which is an acronym for the average reasonable man, if the average reasonable man can figure out that that's who you're talking about, and while some of it, or nearly all of it is true, that portion which is not true can result in a lawsuit. So that's what you need to be careful about. And the way you solve that is to get a release. I was a lawyer for conviction with Hillary Swank and Sam Rockwell, and there were people from whom we did not get releases. But we put in the script, we put words in their mouth that came from the court transcript of what they testified to. So it was 100% true, and we didn't get a release, and we got errors and omissions insurance, and the picture went on to make money. So it was a calculated risk, but that risk took hours and hours to figure out and plan for.
Thank you.
Right on. Oh, I'm sorry, Mike.
That's okay. I don't have much to add, except, I don't know if you all saw the Scientology documentary on HBO, but there were well over 100 attorneys working on that because even though they wanted to make sure that their film was ironclad, even though there was still a strong likelihood that they would be sued. Because if you're dealing with a litigious person and you're projecting somebody in a bad light, whether or not it's going to be a successful lawsuit, there's a strong likelihood that person is going to come after you.
Have we got like just a couple more minutes, or we just do one more question? This gentleman back here.
Concerning releases and street scenes, how unrecognizable do people have to be? People get back of their heads and things like that. Do they need releases?
You can't, the statute in New York says you can't use a person's name or likeness for purposes of advertising or trade, okay? If you watch Arthur 2 and you look carefully, as there's a scene on across from St. Bart's, you can find me crossing the street, okay? I never brought an action. It doesn't matter. It didn't make a difference to me. And if it's not used for advertising or trade, there's at least an argument that there's no clearance required. Crowd scenes are very, very difficult to analyze, and they are case by case. Just like walking down the street, they're all case by case.
And it's about how much risk you're willing to take on. I, as an attorney, I'm supposed to be conservative and tell you whatever you do, do everything you can to avoid risk. The reality is that you may not be protected simply by putting up a sign, say, filming here by entering, you agree to have your image. And the person can still say, I didn't see it, and I'm suing you. So, again, what Mark said, we can't just tell you that this is okay or this is not okay. More likely than not, I as an attorney am going to tell you it's not okay.
Any final thoughts, gentlemen?
Yeah, one, and it didn't come up. Every piece of music that you have in your film requires at least 2 contracts. One for the underlying music, the song, think of it as the sheet music, and the other is for the recording. Okay? They're very different. You might own the recording because you might hire a band to record a song that was written by somebody else, and then you would own the recording. That's one part of it. But if you're going to license music in from third parties, every piece of music has a minimum of 2 contracts, one for the recording and one for the publishing, which is sometimes, I cleared songs with 20 publishers. So you have to be very, very careful.
And don't assume that things are going to work out just because you got a festival license. Warner Brothers is going to give you maybe a free festival license, but they're going to demand $25,000 to $30,000 to $1 million for a great recording. So don't just come to the conclusion that you're in the clear because you're using that music in the festival.
Just want to say thank you very much, gentlemen, and be sure to stick around. Marc's got leading a panel discussion for film financing and distribution.
With a banker.
With a banker. And it's coming up at 12 o'clock.